Hi everyone, this is Heather Lawton from the Flourish Academy. This is episode 375. Today we're talking about copyrights, and I want to start by saying that in the most simplest of cases, if you are a wedding or portrait photographer and you are hired by a private client to take their photos, you own the copyright to those images. The photographer, in most cases, almost always owns the copyright to the photos. There are some unique situations, but I would like to read to you from thelawtog.com because I am not a lawyer and you should definitely seek professional advice. I'm going to post the link for this article below, but let me say that under the Federal Copyright Act of 1976, photographs are protected by copyright from the moment of creation. And according to the U.S. Copyright Office, the owner of the work is generally the photographer or, in certain situations, the employer of the photographer. Even if a person hires a photographer to take pictures of a wedding, for example, the photographer will own the copyright in the photographs unless the copyright in the photographs is transferred in writing and signed by the copyright owner. And the article continues on, and there are some FAQs if you're unclear, but if you are being hired or you are taking photos for a private client, I'm saying the word private because I'm making the distinction from commercial, that's a different topic, then you own the copyright to those photos. Now the reason I'm making that distinction is because here at the Flourish Academy, we are primarily focused on people who are hired by private clients. I don't deal a lot in commercial work, although I have many friends that do, and that's a totally different subject because a lot of time corporations will hire you and they will call it work for hire. And in the contract, it clearly states that that corporation owns the copyright to the photos. Anything you take, they own, but you know that going in because you sign it. If you are not commercial or in that situation, then you will always own the copyright to the photos that you take for your client. Now, you can transfer the copyright, and I have done that once in 15 years. I transferred the copyright, and let me be clear, I sold the copyright. I did not do it for free, and I sold it to HP. I did some speaking for Hewlett-Packard years ago. They are wonderful. I have a great relationship with them, and they asked me if they could purchase the copyright to a few of my photographs to use in their sales toolkit. I was completely flattered. What an honor. So I said, absolutely. So I charged them. I did a little bit of research. I charged them a fee and I transferred the copyright to them. Now in our agreement, it stated that I was still allowed to use those photographs. So I can still use them in my promotional material, but I no longer own the copyright to those photos. They can do whatever they'd like with them. And I was A-okay with it because I transferred it and I sold the copyright. In most situations, as a portrait or wedding photographer, this is not the case. You own the copyright. That is black and white. Take it up with the U.S. Copyright Office. That is what it is, period. Now, where it gets a little bit gray, and there's some confusion, is what about photographers working for photographers? So you have someone that is second shooting for you, or you are the second shooter. In that case, whoever takes the photos owns the copyright. There's no question. But if you are second shooting for another photographer, then you should probably have an agreement with that photographer. Most likely they have an agreement or a contract when working with you that says, yes, you own the copyright, but here are the stipulations in terms of how you can use those images. When I have second shooters working with me, I have an agreement. It's a contract we both sign that says they retain the copyright, they own the copyright, that's no problem, and they are permitted to use the photos that they take at my event in their portfolio once they have been delivered to the client and they are in that set of images. So what I mean by that is they can't use any images that ultimately did not go to the client. Now the way I work that is I will edit the wedding and then I will use Lightroom to filter out my second shooter's photographs and I will send them to them via Dropbox and I'll say, hey, you can use all of these photographs in your portfolio after X date because I've delivered to the client and those photos ended up in the final cut. The reason for that is I don't want them to post something that the client didn't get, because what if the client sees it? If the client sees that image and says, wait a minute, I didn't get that photo, then they start wondering, what else didn't I get? and it could get a little hairy. So I just want to avoid that, and I do it up front with proper agreements and signed contracts. If you're all loosey-goosey about this and you start to experience some issues, I'm gonna ask what your role is in that. Whose fault is that if you don't have an agreement or you haven't talked about those stipulations? Okay, so that's if I have someone second shooting for me. If I am second shooting for someone else, I will ask them directly, how would you like me to use these images? May I use them in my portfolio if so inclined, and what are your stipulations? And I will respect that because they are hiring me, but I still own the copyright to those photos. If you have any questions, please post them below. I have one more thing to cover. If you are in a situation where you are mentoring with another photographer, whether you are the mentor or the mentee, then this is something that you need to discuss ahead of time, again via an agreement. Hey, how are we going to share the images with this client, and what are those stipulations in terms of what you can use and what I can use? And listen, I said it in a previous video, there's no such thing as over communication. You have to talk about these things prior to the event. So I have a mentoring session coming up with a good friend of mine, and we're photographing a bride and groom. Now, I will say to her, you can use these images however you'd like. I'm going to use my images. We're going to gift them a set of those images to the client to thank them for modeling us for the mentoring session, and we'll discuss who is going to gift those images. So in previous sessions, what I have done is I have said to the client, the mentoring client, so this is the photographer, as well as the modeling client, I have said, you can expect to receive 2 galleries. I will edit my photos and deliver a small gallery to you. I usually promise them between 10 and 20 photographs from a mentoring session. And this is a discussion we have ahead of time. And then I will say to the person I am mentoring, you may deliver a gallery to that client and you can edit them yourself. And that's just a gift to the client. So the client, we're thanking them for their time. Who owns the copyright to those photos? Well, obviously, based on the copyright laws, the person who took the photograph owns the copyrights. Now, it's just a matter of good stewardship as to how you use those and the agreement that you have with that photographer, but it should be discussed ahead of time, because what you don't want to happen is for you to do something or your client to do something that's maybe not appropriate and you haven't discussed it, and then who's at fault, and it just gets kind of strange. So you want to take care of that ahead of time. Are you allowed to use these images in your portfolio? Who is communicating with the client? What are they communicating? But again, as a photographer for portraits and weddings, non-commercial, you always own the copyright to your photos. Whether you transfer them or not to someone is up to you, although I find that to be exceedingly rare. Have you ever run into any issues with copyright? Has a client ever asked? You can leave a comment, any questions. Now, I release my copyright to my client for personal use only, and there's a stipulation in my contract that says, hey, you can print these, you can create your own album, you can do whatever you want with your photographs. I own the copyright. It's a limited release. You can do whatever you want. You just cannot sell them. I just thought of this. I had a story from a few years ago where a client who I had photographed many years ago came to me and said that she had a headshot session with a photographer, and he had started using those in billboards and for marketing, and she wanted to know if she should be compensated for that. To which I said, what does your contract say? So she pulled out the contract, and the contract said exactly what I thought it would say, which is what mine says, that the photographer can use the images however they see fit, including marketing, advertising, and selling, because the photographer owns the copyright. So there was nothing she could do about that situation. I kind of think that the photographer, maybe as an act of goodwill, should have reached out to the client and said, hey, I'm going to put your face on a billboard. That would have been nice to know, but they didn't. They weren't required to do that, and they didn't have to. And she was just wondering what rights she had as the client. And really, in that situation, she really didn't have many rights because she had signed a contract. So read your contracts, make sure you know what you are giving your client. And if you're not sure they understand, then read it to them and make sure that it's very clear how you're going to handle their images, so there aren't any hurt feelings or incidents that are less than ideal. I hope that you found this useful. I'll see you in the next video.